Good afternoon, and welcome to the Committee of Adjustment meeting for Friday, September the 25th. I will call the meeting to order and ask the members if anyone has a declaration of pecuniary interest or general nature thereof.
No.
Okay, hearing none. Could I have a mover and a seconder to adopt the minutes of August the 28th? Julie and Gary, thank you.
Moved by Julia Shortreed, seconded by Gary Trapp. Be it resolved, the Committee of Adjustment hereby approves as circulated the meeting minutes of August 28, 2020.
All in favor?
Oh, sorry, I have to read it, my mistake. So Liz Danielson, yea or nay?
Yes.
John Rogers, yea or nay?
Yes.
Julia Shortreed, yea or nay?
Yes.
Gary Trapp, yea or nay?
Yes.
And Chris Woods, yea or nay?
Yes.
And that motion's carried.
Thank you. We have no business arising from the minutes, so we will move on to new business. And the first application is from Mr. Shepherd on Twin Rocks Lane in Stanhope, Couchog Lake. So I'd ask Sean to give us his report.
Okay. 1 second, Mr. Shepherd. I'm going to give a presentation first, and then you'll be able to speak following that. Yes. This property is located at 1265 Twin Rocks Lane. The lands are currently zoned shoreline residential 2 and designated waterfront under the official plan. The property is approximately 0.49 acres in area with 29.2 meters of frontage on Couchog Lake. The surrounding uses are generally shoreline residential. The lands are currently developed with a dwelling, a gazebo, an outhouse, woodshed, boathouse, dock, and a shed. The owner is proposing to construct a 360 square foot single story garage. The garage will be located behind the existing accessory structures and be 7 meters from the high water mark. The garage is proposed to be located in the current parking area of the subject lands. The proposed garage will be located within the minimum 30-meter setback from the high water mark. A greater setback is not possible given the location of the dwelling, the lot size, and topographical constraints. Therefore, in order to construct the proposed garage in the location that's being proposed, the following variance will be required, and that is from section 4.2.8 of the zoning bylaw to reduce the minimum setback from the high water mark from 30 meters to 7 meters to permit the construction of a 360 square foot, 1-story detached garage. Notice of the application was posted on the property, posted on the township website, and circulated to property owners within 60 meters of the subject lands and to the Couchog Lake Property Owners Association. 4 letters of objection were received, and staff are recommending approval of the proposed minor variance with the following conditions. 1, confirmation be provided from an Ontario land surveyor that the proposed structure is not located closer than 7 meters from the high water mark prior to any clearing or site alteration or the issuance of a building permit. 2, that confirmation be provided from an Ontario land surveyor that the proposed structure is not located on the right-of-way known as Twin Rocks Lane prior to any clearing or site alteration or the issuance of a building permit. 3, the original shore road allowance in front of the subject land being stopped up and closed prior to any clearing or site alteration or the issuance of a building permit. And 4, that appropriate construction mitigation measures be implemented, which shall include the erection and maintenance of silt fencing between the proposed building and the shoreline.
Are there any questions from the committee at this point on the report itself? And then we will hear from Mr. Shepherd.
Through you, Madam Chair. Just in the conditions that you have, this being a garage, I don't see the standard condition about not being occupied for residential purposes. Is that intentional, or should we add that in?
I left it out intentionally because it's a single-story garage. If it was a two-story garage, I would typically include that condition where the second story was proposed to be used for storage only. We can still certainly include that should the committee wish.
Unfortunately, through you, Madam Chair, I've seen situations where garages, single story, turn into residences as well. So I would prefer to see that condition added in.
Okay, we can speak to that. Are there any other questions from the committee at this point?
Sorry, through you, Madam Chair, and I'm not sure whether this is a question to Sean, but I find the condition with respect to the stop up and close requirement. I have to admit I'm hesitant about that being that we approve with that condition. I would almost prefer that we defer this application rather than approve it until the stop up and close has taken place. I'm not sure if I'm reading the map correctly that's attached to the report, but it would seem to me that this property, a lot of the structures are on the original shore road allowance, and if that's the case, Mr. and Mr. Shepherd don't actually own the property, and I'm not sure if they have the authority to make the application for a minor variance on property that they do not own. So and it's not that I think your recommendation, your report is solid. Other than I'm just concerned about the process that would apply in these particular circumstances.
Want to speak to that, Sean?
Yeah, so typically the way we would deal with an application where somebody's building or proposing to build on the shore road allowance, we include that as a condition because right now you're correct, they could not get a building permit if they do not own that shore road allowance, but it is possible once we have the survey that a significant portion of the shore road allowance is flooded and the structure may not be located on the shore road allowance. So that's typically why I have not required that to happen beforehand, but it rather included as a condition. Also, the process to close a shore road allowance can take 6 months to a year. So I can understand why an applicant would want to have a minor variance approved prior to actually going through that lengthy process, just to have their application turned down.
I see the sense in that. Okay, if we could hear from Mr. Shepherd. Mr. Shepherd, if you'd like to speak to your application.
Yes, I'd like to. May I speak?
Yes, proceed, please.
Dear committee members, I purchased this half-acre lot on Lake Couchard property in June 1962. I built the cottage in 1962. In 1963, I built a 12 by 18 boathouse on a 100-foot lot dock. I was not told at the time that I had to buy the underwater property. Could this be called a grandfather clause so that I don't have to pay for that property that's underwater? Should I really be asked for it now at this meeting today? You will all be asked to vote for or against it in regarding to the 18.5 by 20.5 foot concrete pad, and which will cost $18,800, and an 18 foot by 20 foot two-car garage. Regarding the back of the garage will be only 7 meters. It should be 30 meters. I have been paying taxes on this property for 57 years. Please vote yes for my two-car garage. The cost of the project will be about $32,000, including the pad and the garage. A project will be good for local contractors. Sincerely, Milton Shepherd. I hope you all vote yes. Thank you.
Thank you, Mr. Shepherd. Are there any questions from the committee of Mr. Shepherd at this point?
Through you, Madam Chair, just want to make sure Mr. Shepherd understands the process about acquisition of the shoreline road allowance and the length of time that it takes to acquire.
Have you spoken to Mr. Shepherd about the process? I believe that Sean has spoken to Mr. Shepherd about the process. And I have also had some conversation with him about the conditions of the application. Did you want to make any further comment, Sean?
Yep, so I have talked to Mr. Shepherd about the process involved with closing the shore road allowance and have advised that it can take 6 months to a year. So it's my understanding that he is aware of that process.
Do we have, go ahead.
Sorry,
Mr.
through you,
Oh,
Madam Chair,
sorry.
through you, Madam Chair, I just wanted to hear that from Mr. Shepherd. I just want to make sure he understands.
What I was planning on doing.
Sorry, Mr. Shepherd.
Yes,
Just hold him on a moment. We'll be right with you.
thank you.
Mr. Rogers, I'm sorry, could I hear your question again?
Through you, Madam Chair, I'm wanting to make sure that I hear from Mr. Shepherd that he understands this, the length of time, and that the fact that this minor variance is conditional. He's not going to be able to construct the pad until the shoreline road allowance has been conveyed. It has been acquired and conveyed to him.
Okay, Mr. Shepherd.
Yes, ma'am.
The committee wants to be assured that you understand the conditions that are part of the approval process, and that the process to acquire the shore road allowance, should you be required to do that, may take a number of months, and that must take place.
Why would it take so long?
It's a legal process that just does take that long. That we have no control.
Okay, can I talk again, please?
Yes, go ahead.
Okay, what I'd like to do is build the pad this year, and because the cost of lumber is so expensive right now, build the two-car garage next spring. I'd like permission to build the pad.
If the application is approved, unfortunately, that won't be possible because you will need to close the shore road allowance like we discussed before. And that can take 6 months to a year to complete, and that needs to be done prior to a building permit being issued.
I don't understand. You told me that if it's approved, I can do the pad on the 15th of October.
No, I'm sorry, that's not correct.
Who's talking now?
This is Sean O'Callahan, yeah.
So when do I have to wait now? Next year?
If the application is approved, yes, you would have to wait until the shore
Yeah,
road
but how
allowance.
about the people that are there? Are they not voting for the project?
We have not reached that point yet.
Well, why don't you have a vote and then we'll see what happens? Because I'm going to have to pay for the underwater flooded property, and nobody told me that in 1962, 63 for a number of years, and now you're telling me I'm going to have to pay for that. I don't get it.
Well, unfortunately, those are the rules that are in place at this time. And,
Well, maybe we could change the rules.
and we
I'm
must.
a senior citizen.
I'm sorry, Mr. Shepherd. Unfortunately, the fact that you're a senior citizen does not have relevance in this particular case.
Doesn't have what?
No relevance to your application.
What has no relevance?
Your age.
My ink,
Your age. The number of.
my age.
Yes.
Okay, fine.
And just one more point, Mr. Shepherd, we need to hear all of the relevant information before we have a vote. And I believe that there are people on the line who wish to speak to your application.
I'm sure they are, and I know all of them, and I know who they are. And I thought they were friends of mine, but I don't think so.
Well, and we do need to allow anyone who wishes to speak to the application that opportunity.
Okay, thank you, I'll wait.
Is there anyone on the line who wishes to speak to the application? If so, please identify yourself and proceed.
Sorry, I'm unmuted now. Can you hear me?
Yes,
It's Norma Goodger here.
good afternoon.
Although I am familiar with Mr. Shepherd's property and Mr. Shepherd himself, my objection to this is not specific. It is specific to this property in that there are already 7 structures on this very small piece of property, and this structure will significantly reduce the amount of shoreline available or land available for absorption of protection of the shoreline. This is already a sensitive area, highly developed, and to put one more structure on a very small piece of property just doesn't make sense to me. I understand why the planner has approved it based on the existing bylaws, but the consultant who's looking at the bylaw revisions specifically says that this is one area that really needs to be considered and altered in order to protect the nearshore environment of the lake. And so I hope that this committee will reject this application based on the fact that it does not meet the intention of the bylaw, which is to preserve the shorelands and to only let development occur in an environmentally responsible manner. So that's and I hope that the objections that have been raised in the letters of objection will be considered, and that this application will be declined, and just say no. Thank you.
Thank you, Norma. Is there anyone else who wishes to speak to the application? If not, do any members of the committee wish to speak to the person who just made a delegation?
Madam Chair, it's Chris Woods speaking.
Yes, go
Can you
ahead.
hear me?
Yes, go ahead.
I'd like to ask a question of Mr. Shepherd, why he feels he needs to build a 2-car garage there when he already has a spot for parking. I'm not quite sure I understand why he feels it's necessary to build a 2-car garage. Could he answer that?
Speak to that?
Yes, go ahead.
Okay, I'm down an 800-foot road that's very slippery in the winter. We have snow anywhere from 84 to 108 feet deep in the winters that have passed. And it's no fun scraping ice and snow and digging snow and everything else off our cars. And so this is why we want to build a 2-car garage, Mr. Wood.
Again, Mr. Shepherd, is there no other alternatives for temporary kind of structures that are not full buildings, but maybe a carport or something like that?
Okay, they're going to have to put in about 10 loads of gravel in order to level the lot. And we're having trouble getting out of the lot because it's slanted. And if you go to the back of the lot, we'll have to have as much gravel that's almost up to your waist at the back of the lot. And so we need a level area so we can get off the lot, which includes this concrete rebar pad. Answer your question, sir.
It does, but it doesn't. Okay, I'd like to hear from the other committee members.
Okay, I would look to the committee for comments or further questions about the application. Comments or
Madam
questions?
Chair, Gary Trapp here.
Go ahead.
Yeah, Madam Chair, I'm assuming that it seems like the main issue is around ownership of the road allowance and property boundaries and such. Is it fair to assume that the right-of-way issues and ownership and exact location of right-of-way would all be part and parcel of this clarification of, an application to purchase the road allowance if the applicant decides to go that route? Is there any need, in other words, to talk about the right of way, or would that be all part and parcel of the process? Thank you.
If you could speak to
Are
that,
you
Sean.
talking about the road?
Mr. Shepherd, I'll answer the question. I'll just be 1 second here.
Okay, thank you.
Yeah, so the survey that's required will determine where the survey is going to make sure that the garage is not constructed on the existing right of way. And the survey is also required as part of the shore road allowance closure, should that be required.
Okay, Madam Chair, just onto that, Gary Trapp here is, are there any setback requirements for the right of way portion that we're talking about?
So there's no setback requirement from a right of way. You just cannot build within the boundaries of a right of way.
Are there further questions about the application from any members of the committee?
Madam Chair, sorry, this is a comment more than a question. Are you planning on having comments later on, or is this the appropriate time to make a comment?
You're more than welcome to make a comment at this time. That's
Okay.
what I'm looking for.
Yeah. Okay. Thank you, Madam Chair. I find this is a very difficult application for us to be considering. That for a number of reasons. One is there is a question has been raised with respect to ownership of the property, and I have a real concern in my mind that I'm not sure if we have the authority as a committee to make decisions on land, not on an application on lands not owned by the applicant, so I'm having a terrible internal conflict with respect to that. Secondly, I am concerned about the concerns that Norma Goodger has raised, and that is to deal with the number of buildings and structures on this property on a lake that I think Sean has mentioned in his report has got to capacity. So I'm a little concerned about whether it is an appropriate application to approve. So I'm having, I'll just say, a lot of difficulty with this particular application.
Other committee comments?
Madam Chair, it's Chris Woods again. Like Mr. Rogers, I am having real difficulty with this particular application. One, for the fact of the structures on the property, size of the property. I know they've got the very hill in the background, so nothing can be done back there. But doesn't mean just because they can't do it back there, they should be allowed to do it closer to the water. And I don't see the actual need for putting in a structure on the property, and I'm not even sure that it would fit with the the fact that we have to go through a variance to get it closer to the water makes it even more difficult. So therefore, I would be very, very, I'm having real difficulty with this one.
So who's this speaking now, Mr. Wood?
That was Mr. Wood.
Yes, it was.
Yeah, okay, thank you.
I would look to other members of the committee to comment. Mr. Trapp and Ms. Shortreed.
Yeah, Madam Chair, Gary Trapp here. Yeah, I share those concerns. The primary thing, again, seems to be around ownership and of the road allowance and the shore road allowance and the right of way, and that certainly needs to be clarified before we can even consider it. I would suggest. I think there's a number of points that were well taken from some of the letters that were presented for this file. You know, I don't think they're probably worth, I'm not sure if this is the appropriate time to discuss those, or maybe later when we get to the point of clarity around the ownership of the property to discuss some of the other issues that were raised in some of the objection letters. But I'm having a difficult time with this as well. And at this point, you know, yeah, would not be supportive at this stage of the process. Thank you.
Ms. Shortreed.
I just wanted to ask Sean, did the ownership of the right-of-way, was it resolved?
No, the right-of-way location and who actually owns it. It appears from the information that I have that it is a private right-of-way that runs over private property, which would mean that Mr. Shepherd owns the property where the right-of-way travels across, but does not have the right to actually build upon that portion of land.
Thank you.
So the right of the way you're talking about is the road, right?
Yes.
It's 14 feet wide. And our lake association has it insured for $1 million, and my own insurance has got it insured for $2 million, and that's in case some kind of an accident happens on the lake, the 1,000, so that the property owners on the road won't have to lose their cottages because of somebody having an accident on the road. Is that clear?
Yes, it's clear. I'm not sure that the insurance is relevant to the actual application.
Well, I've got it on my insurance policy. And
I'm sorry,
the
Mr.
actual
Shepherd.
people on the road are insured for $1 million.
The issue of insurance is not something that's relevant to this particular application. And
Sure, okay,
and
but
whether
you
it's
do have a right of way, and I'm not building on the right of way.
But that's the purpose of the survey, in order to determine that. Are there any other comments or questions from the committee? So at this point, I would ask Sean to read the resolution. Could I have a mover and a seconder to put the motion on the floor?
Madam Chair, before that, I'd like to make a motion to defer the application until the shoreline road allowance has been acquired. Not sure if there's a seconder for that.
The point that Mr. Callahan was making about that is that it's quite a lengthy and expensive process to go through, and only to determine later on that we are not going to approve the application, which is why we make it part of the conditions of approval. If the application is denied, it's irrelevant. If it's approved, he would at least know that his application for a minor variance is approved, and he won't have to worry. It's legitimate to spend the money. But it's a large expense to have if you find later on that you're not going to receive approval.
I'm sorry, but Madam Chair, that the concern I have is that the application is on the basis that the applicant is the owner of the property, and he's made a declaration saying that he is the owner of the property. If he's not the owner of the property, I'm not sure we have the jurisdiction to actually make the decision.
We're talking about the acquisition of the shore road allowance, not the road allowance or the right of way.
That's correct.
So, I mean, the information that I have looking at surveys of surrounding properties suggests a significant portion of the shore road allowance is in fact flooded. So I would be, it's my understanding that the full 20-meter shoreline road allowance is not present, and it's quite likely that the building will not be located on the shore road allowance, but a survey will be required to confirm that. So that's why I've included that as a condition.
Do other committee members see merit in deferring the application as opposed to voting on approval or denial of the application?
Madam Chair,
Yes.
Gary Trapp. Yeah, I see merit to deferring the application, largely for the benefit of the applicant, so some clarity can be made around the ownership, the timing, the issues, because I'm not convinced at this point that it is crystal clear to all parties involved. So I think deferral for the reasons that Mr. Rogers has suggested, but also for the benefit of the applicant, so that he, if it were declined, for example, that the applicant would not have to go through that process of applying again. So I see the merit of deferring myself. Thank you.
I'm sorry, I'm really not seeing the merit in deferral. I can see merit in approval or denial based on the conditions that have been laid out here. But I don't see, unless you believe that there's a need for further clarification between our planner and Mr. Shepherd to defer it. I just don't see what the purpose of deferral would be.
Madam Chair, it's Chris Wood speaking. I agree with you. I don't see the rational reason to defer this application if he's going to end up incurring more expenses if the application is turned down. He's gone through expenses that he didn't need to go through. If it's approved, then to proceed with the expenses would make then more sense.
Shall we put a motion on the floor? See, I just want to hear from other members on the issue of deferral. Ms. Shortreed?
I don't understand why we would want a deferral.
I'm with you there. I think what we'll do for now is put the motion on the floor. Could I have a mover and a seconder to put the motion on the floor? Julie Shortreed. This is simply to vote. It's not to approve or deny. I have to have a seconder for a motion. I don't see unanimous approval or agreement for deferral.
Madam Chair, Gary Trapp here. I don't know if this is the right place to ask this question, but if the committee, and I'm not saying the committee would, but if the committee were to turn this down, what would be the major reason, or what would be the reason for the objection to this at this point? It's maybe that would help clarify where we're at. I'm not sure. Thank you.
Do you want to speak to that?
Sorry, I'm not sure I understand the question, Gary.
He's asking what the rationale would be for us to deny the application. I think the concerns are that there's, I guess I would like to ask Sean if you have any information on the percent lot coverage, because one of the concerns has been raised is the number of structures on the on the water side of the property?
Yes, so you are allowed 5% lot coverage for all your accessory buildings combined, and with the construction of the proposed garage, Mr. Shepherd would be within that 5% requirement. He would not exceed it.
Otherwise, the concern would be that there are a number of structures in close proximity to the high water mark. And it is a new structure being built within the 30-meter setback from the high water mark. At least it would appear that way until there was a survey conducted. So
Madam
we can
Chair.
make this a decision. Go ahead, Mr. Woods.
Madam Chair, I will have difficulty voting for this application. And the reason I have difficulty is because of the proximity to the high water mark of putting a new structure, and why we would allow a new structure to go on a property that's closer to the water when there, in my mind, serves no purpose for putting that building there other than a convenience to the owner. And I don't think that's a very good reason to put that structure there.
Other comments from the committee? I'm going to ask if someone would second the motion, just to put it on the floor to be read and voted on. Seconded by Mr. Trapp. If you could read the resolution, please.
Is that the resolution I originally had as part of my recommendation to support the application?
Yes.
Okay, so moved by Julia Shortreed, second by Gary Trapp, be it resolved the Committee of Adjustment hereby approves minor variance application AHMV 1520 submitted by Shepherd to seek relief from section 4.2.8 of the zoning bylaw to reduce the minimum setback from the high water mark from 30 meters to 7 meters to permit the construction of a 360 square foot, 1-story detached garage, subject to the following conditions. 1, that confirmation be provided from an Ontario land surveyor that the proposed structure is not located closer than 7 meters from the high water mark. 2, that confirmation be provided from an Ontario land surveyor that the proposed structure is not located on the right-of-way known as Twin Rocks Lane. 3, the original shore road allowance in front of the subject lands being stopped up and closed prior to any clearing or site alteration or the issuance of a building permit. And 4, that appropriate construction mitigation measures be implemented, which shall include the erection and maintenance of silt fencing between the proposed building and the shoreline. Liz Danielson, yea or nay?
Nay.
John Rogers, yea or nay?
Nay.
Julia Shortreed, yea or nay?
Nay.
Gary Trapp, yea or nay?
Nay.
And Chris Woods, yea or nay?
Nay.
Okay, that motion's not carried. I do have a second motion for denial if there's a mover and seconder for that.
Could we have a mover and a seconder for a motion of denial? Councillor Shortreed and Mr. Trapp.
Moved by Julia Shortreed, second by Gary Trapp. Be it resolved, the Committee of Adjustment hereby denies minor variance application AHMV 15 submitted by Shepherd. Liz Danielson, yea or nay?
Yay.
John Rogers, yea or nay?
Yay.
Julia Shortreed, yea or nay?
Sorry, you're muted.
3A.
Gary Trapp, yea or nay?
Yay.
Chris Woods, yea or nay?
Yay.
That's motion's carried and the application is denied.
Okay, our next application is by Hungerford on Raven South Shore in Sherburne on Raven Lake. If you could read your report, please.
Certainly. This property is located at 15423 Raven South Shore, water access only. The lands are zoned shoreline residential 2 and designated waterfront under the official plan. The lands are approximately 1.6 acres in area with 82 meters of frontage on Raven Lake. Surrounding uses are generally shoreline residential, and the lands are currently developed with a dwelling, 2 sheds, a dock, and a sleeping cabin. The owner is proposing to construct a 226 square foot addition on the side of the existing dwelling. The existing dwelling is currently set back 8.3 meters, and the proposed addition will be 14.3 meters from the high water mark. The property was subject to a minor variance application, AHMV 1016, back in the year of 2016, to reduce the setback from the high water mark from 15 meters to 12.2 meters in order to construct a 372 square foot addition on the rear of the dwelling. This application was approved and the addition has since been completed. This new proposed addition will be located on the southwesterly side of the existing dwelling. The proposed addition will not project beyond the front face of the existing dwelling. However, the existing cottage is on a slight angle combined with an irregular shoreline, which results in a lesser setback. The lands are limited in available building locations that would conform to the zoning requirements due to topographical constraints. The applicant will require the following minor variance, and that is from section 4.10.52 of the zoning bylaw to permit a reduction in the required setback from the high water mark from 15 meters to 14.3 meters for the purpose of constructing a 226 square foot addition to an existing dwelling. Notice of the application was posted on the property, posted on the township website, and circulated to property owners within 60 meters of the subject lands. No objections have been received. 2 letters of support have been received. Staff are recommending approval of the proposed minor variance with the following conditions. 1, that confirmation be provided from an Ontario land surveyor that the proposed addition is not located closer than 14.3 meters from the high water mark prior to any clearing, site alteration, or the issuance of a building permit. 2, the sleeping cabin being inspected to confirm it complies with the requirements of a sleeping cabin in section 4.2.10 of the zoning bylaw. 3, that any on-site sewage system permits and reviews required by the township have been obtained and approved prior to the issuance of a building permit. And 4, that appropriate construction mitigation measures be implemented, which shall include the erection and maintenance of silt fencing between the proposed building and the shoreline.
Is there anyone here who wishes to speak to the application? Mr. O'Grady, are you present?
I am.
You wish to speak to the application?
Madam Chair, thank you very much, and committee members, good afternoon. I wish to speak to it just for a clarification, and that is that the building, the proposed building will be used as a screened-in porch and a covered porch, which would basically be open and certainly not deemed to be habitable use. That's all I would basically like to say. I think that the application speaks for itself. We're certainly prepared to adhere to the recommendations. Thank you.
Are there questions from the committee, either of Sean or of the representative of the applicant?
Madam Chair, it's Chris Woods here.
Go ahead.
I'm just a slight bit confused, and it's not hard for me to get confused. Why the application refers to and talks about a bunkie. So this really is a question, I think, for Sean. Why has that any relevance to this application?
That condition wasn't. So I included that condition. It was included on the previous minor variance application. And just during the site visit, it seemed like it may exceed the minimum size requirements. So that's why I include that, just so we can clarify that it does in fact still meet the zoning bylaw prior to issuing any new permits on the property.
But if it doesn't adhere to whatever the requirements are that are specific to this application, what is the recourse here? Does that mean that thing has to come down?
So it would mean that the sleeping cabin would need to be brought into compliance with the zoning bylaw. Following that, then a permit could be issued for this proposed screened-in porch if it is approved today by the committee.
Again, I'm still not quite sure why that has anything to do with approval of this application or denial of this application.
So it I guess it's not entirely relevant to the proposed work that will be completed, but the applicant is requesting new construction on the property. And before I'd be comfortable with a permit being issued, I'd like to make sure that any existing development continues to comply with the zoning requirements. And that was the purpose of that condition. It's simply, if the committee includes it, it would simply be just a quick inspection of the property or of that building.
Madam Chair, if I may.
Yes, go ahead.
Madam Chair, that we're certainly welcoming that inspection. The present bunkie does not exceed 485 square feet as approved, and would certainly entertain as part of the condition, part of the conditions that an inspection be done as soon as possible.
Thank you.
Okay, the other question I have, and I think I understand what's going on. So the screened-in porch, which will have a roof on top of it, will be simply that, a screened-in porch of the existing deck that's there? Or is the deck going to be enlarged?
No, it'll be on the existing footprint of the existing deck that was built under permit.
Okay, so it's putting one of the concerns, Mr. O'Grady, and you know this as well as anybody, that the screened-in porch becomes a very nice place where it gets glassed in and becomes a seasonal four-season build structure. And I don't think that would be what the committee would like to see. Certainly, I would not like to see that. So I would request that we put some sort of restriction in that it can't be made into a full seasonal extension of the cottage.
Well, I agree, and I think that the manner in which they're done today, that you buy windows that not only have windows in them, these plastic sheen windows, but screens also. Just the fact that they're not habitable, even though they're attached to a main building, they're not deemed habitable in any way, shape, or form. They are defined clearly as seasonal. So there would be no way that, unless an individual did enclose it later on by removing the screens, etc., and starting to put regular windows in and become a greater gross floor area than it is right now. But I don't think that's the case with us here.
Can you speak to that?
Yeah, so what I would recommend, if the committee does approve the application, I can include in the decision that this approval applies only to a screened-in room. That way it's quite clear that it was never intended to be habitable space.
That's correct.
Yeah.
Other questions or concerns about this application? If there are no concerns, could I have a mover and a seconder for the motion?
I'll move.
I'll move. I'll second.
Okay, I'll move by Mr. Rogers, seconded by Mr. Woods.
Moved by John Rogers, second by Chris Woods. Be it resolved that the Committee of Adjustment hereby approves minor variance application AHMB 19 to seek relief from section 4.10.52 of the zoning bylaw to permit a reduction in the required setback from the high water mark from 15 meters to 14.3 meters for the purpose of constructing a 226 square foot screened in room to an existing dwelling, a variance of 0.7 meters. Subject to the following conditions. Confirmation be provided from an Ontario land surveyor that the proposed screened-in room is not located closer than 14.3 meters from the high water mark prior to any clearing or site alteration or the issuance of a building permit. 2, the sleeping cabin being inspected to confirm it complies with the requirements of a sleeping cabin in section 4.2.10 of the zoning bylaw. 3, that any on-site sewage system permits and reviews required by the township have been obtained and approved prior to the issuance of a building permit. And 4, that appropriate construction mitigation measures be implemented, which shall include the erection and maintenance of silt fencing between the proposed building and the shoreline. Liz Danielson, yea or nay?
Yay.
John Rogers, yea or nay?
Yay.
Julia Shortreed, yea or nay?
Yay.
Gary Trapp, yea or nay?
Yay.
Chris Woods, yea or nay?
Yay.
That motion's carried.
Madam Chair, may I say a word before that issue is closed?
Yes.
If I can help the situation out, I know the planner, Sean, had indicated on his wording that it be called a room. If you look under definition, under porch, in the zoning bylaw 3.124, if you called it a porch, it would then be deemed a structure attached to a permitted building which is covered and enclosed partially or wholly on its sides by screening. So if you take the word room out, that he's actually going to build a porch or some porch, and that will cover the use. Just a suggestion.
Yeah, unfortunately, because we've already voted on that resolution.
All right, that's fair enough, and I just thought I'd bring that up for clarity, that the word porch and room, two different definitions. Okay, thank you, Madam Chair, Committee.
Okay, so we can't alter the motion at this point in time.
I think the resolution's still clear in what the intent
What's
was.
intended.
That's fine.
Thank you. We will take that under advisement for future wording.
Thank you, Madam Chair.
Okay, the next application is by Gilbert on Comac Crescent in the Township of Sherburne on St. Nora's Lake.
Yes, this property is located at 1250 Comac Crescent. The lands are zoned shoreline residential 2 and designated waterfront under the official plan. The property is approximately 0.91 acres in area with 38.1 meters of frontage on St. Nora's Lake. Surrounding uses are generally shoreline residential, and the lands are currently developed with a dwelling, a woodshed, a sleeping cabin, and a dock. The owner is proposing to construct a 576 square foot single-story carport. The carport is proposed to be located in the current parking area of the subject lands. The proposed carport will be located within the minimum 30-meter setback from the high water mark. A greater setback is not possible given the location of the dwelling and other topographical constraints. The applicant will therefore require the following 2 minor variances. 1 from table 2 of the zoning bylaw to reduce the minimum setback from the high water mark from 30 meters to 25.43 meters for the construction of a 576 square foot single-story detached carport. And also from table 2 of the zoning bylaw to reduce the minimum setback from the interior lot line from 3 meters to 0.9 meters to permit the construction of a 576 square foot single-story detached carport. Notice of the application was posted on the property, posted on the township website, and circulated to property owners within 60 meters of the subject lands. No objections have been received, and staff are recommending approval of the proposed minor variance with the following conditions. 1, confirmation be provided from an Ontario land surveyor that the proposed structure is not located closer than 25.43 meters from the high water mark prior to any clearing or site alteration or the issuance of a building permit. 2, that confirmation be provided from an Ontario land surveyor that the proposed structure is not located closer than 0.9 meters from the interior lot line prior to any clearing or site alteration or the issuance of a building permit. And 3, that appropriate construction mitigation measures be implemented, which shall include the erection and maintenance of silt fencing between the proposed building and the shoreline.
Mr. O'Grady, you wish to speak to this application?
I think the application, Madam Chair, is clear as to what relief that we are seeking. Again, the subject area where the carport is we want to build that is very limited. There's no other place on the lot that we could build that at this point in time. The people do travel back and forth, and in the wintertime, rather than going up to the back, up the long roadway to get to the storage garage up there, that they wanted to build a carport that was very close to their home so they could just come get out of the snow, ice, etc., and it'd be more convenient for them. So thank you, Madam Chair.
I've got to say that this particular application is one where when you initially look at the paperwork, it looks questionable. When you arrive on the property and see the situation, it brings a different picture into mind. I would ask if there are any questions or concerns by the committee about this application.
Through you, Madam Chair, to Mr. O'Grady, perhaps just a confirmation of when the work was done, that there's obviously been a lot of significant boulder placement and there's already been the gravel put down. When was that work done?
I don't have an answer for that, sir. I'm not aware of when that was done.
Okay, thank you.
Other questions or concerns about this application?
Madam Chair, Gary Trapp here.
Go ahead.
Yeah, no, just echoing the your comment that at first on paper it looks like there's two significant exceptions being asked for, but I have no difficulty with high water situation, and the side yard. I think our rules are quite liberal already, and normally I think we need to take those fairly seriously for any side yard setback exceptions. In this case, just a comment, I think the fact that the applicant owns the adjacent property, which in itself would not be reason necessarily just to approve it, but he does own it, and it's fairly steep there, so there's nothing else really that I don't see any future interference, whether this applicant owns the property in the future or not, so I don't have any problem with it.
Thank you.
Thank you.
Other comments or questions?
Madam Chair, it's Chris Woods, and it's not a concern. It was more an understanding, and Gary mentioned that the property owners own the property adjacent, and in my discussion when I was there, they said for them to merge that with their property, it would cost them over $5,000. I guess that's in legal fees and land transfers and whatever. But they said if we were to sell the major building, then it automatically would be merged into one lot. Is there something that I don't understand about the property transfers, that if they were to sell their main building, that side lot would automatically become part of that and as one lot? And maybe Sean can answer that.
I wish I could, but that is an extremely complicated topic, and it would depend on several different factors on what would cause a lot to merge two adjacent parcels. So, yeah, unfortunately, I don't have a concrete answer for you.
Okay, thank you. I don't really have any objection to what's going on here.
Thank you. Could I then have a mover and a seconder to put the motion on the floor? Julie Short.
I will so move.
Mr. Wood, thank you.
Moved by Julia Shoreby, second by Chris Woods. Be it resolved, the Committee of Adjustment hereby approves minor variance application HMV 2020 submitted by Gilbert to seek relief from Table 2 of the zoning bylaw to reduce the minimum setback from the high water mark from 30 meters to 25.43 meters to permit the construction of a 576 square foot, one-story detached carport, and from Table 2 of the zoning bylaw to reduce the minimum setback from the interior side lot line from 3 meters to 0.9 meters to permit the construction of a 576 square foot detached carport, subject to the following conditions. 1, confirmation be provided from an Ontario land surveyor that the proposed structure is not located closer than 25.43 meters from the high water mark prior to any clearing or site alteration or the issuance of a building permit. 2, that confirmation be provided from an Ontario land surveyor that the proposed structure is not located closer than 0.9 meters from the interior lot line prior to any clearing or site alteration or the issuance of a building permit. And 3, that appropriate construction mitigation measures be implemented, which shall include the erection and maintenance of silt fencing between the proposed building and the shoreline. Liz Danielson, yea or nay?
Yay.
John Rogers, yea or nay?
Yay.
Julia Shortreed, yea or nay?
Yay.
Gary Trapp, yea or nay?
Yay.
Chris Woods, yea or nay?
Yay.
Motion's carried.
Thank you. So our final application is by Webb on Wolf Circle in Sherborne, Quagama Lake.
This property is located at 1047 Wolf Circle. The subject lands are zoned shoreline residential 2 and designated waterfront under the official plan. The lands are approximately 0.65 acres in area with 31.4 meters of frontage on Quagama Lake. The surrounding uses are generally shoreline residential and the lands are currently developed with a detached garage. The owner is proposing to construct a 1900 square foot, 2-story dwelling. And just to clarify that, it's my understanding now that it's actually a walkout basement, so not a traditional 2-story dwelling, but I'll let the applicant's agent speak to that in a moment. Existing and proposed site infrastructure and an existing hydro line running through the property line significantly limit the available building envelope. The lot is well vegetated, creating an effective natural buffer between the proposed building footprint and the water. The proposed building location is on a plateau of land that would accommodate the proposed building without significant site alterations. The following minor variance will be required, and that is from Table 2 of the zoning bylaw to permit a reduction in the required setback from the high water mark from 30 meters to 22.86 meters for the purpose of constructing a 1900 square foot dwelling. Notice of the application was posted on the property, posted on the township website, circulated to property owners within 60 meters of the subject lands and to the Quagama Lake Property Owners Association. One objection has been received from a neighboring property owner. Staff are recommending approval of the proposed minor variance with the following conditions. 1, that confirmation be provided from an Ontario land surveyor that the proposed structure is not located closer than 22.86 meters from the high water mark prior to any clearing or site alteration or the issuance of a building permit. 2, that any on-site sewage system permits and reviews required by the township have been obtained and approved prior to the issuance of a building permit. And 3, that appropriate construction mitigation measures be implemented, which shall include the erection and maintenance of silt fencing between the proposed building and the shoreline.
Mr. O'Grady, you wish to speak to this application? Mr. O'Grady? Mr. O'Grady, are you on the line?
Are you there?
Yes, we're here. If you would speak to this application.
Okay, thank you very much. Yes, the application basically is to build a single-family dwelling on a vacant lot, to build it at 75 feet back from the high water mark. There's presently a garage that is situated on the property that was built under permit. the configuration of the home would be such that we could not move it back to the 30 meters. The owner has produced a hands-on facsimile of the way that he proposes to build the house, taking into consideration the side lots, taking into consideration the size of the septic system that would have to go on the lot, taking into consideration drilling a well, the required setbacks, rules and regulations governing those. It is a very small lot, and we're hoping to set the house back the 75 feet in lieu of the 30 meters as required.
Thank you. I believe that we have another gentleman on the line who wishes to speak to the application. Mr.
Yes.
Webb, you wish to speak to the application?
Yes, hello, Madam Chair. My name is Andy Bednars. I'm the adjoining property owner. I'm representing my parents who are the adjoining property owners.
Go ahead.
Okay, I believe I sent in some drawings for you people to have a look at to kind of improve the spatial reality of the site plan that was provided by Mr. Webb. Does everybody have that available to them?
Mm-hmm.
Yes, I believe we do.
Okay, do I need to explain how I got from Plan 1 to Plan 3, or can we go straight to Plan 3?
I think unless the committee has questions, that we can go straight to Plan 3.
Okay, as you can see by Plan 3, I've outlined what is the current permittable building envelope according to the local bylaws for an SR2 zoning. I put forward that there is entirely enough room to reposition that cottage within that building envelope. And since you are able, I was informed by planning that you are able to move, or you are able to put septic systems within the 12-meter setback at the rear of the property. I believe there should be no problem with them complying with the current bylaws. This is all in, I've known the Webb family for a long time. I hope this isn't causing any problems, but my main concern is with keeping the lakes in good condition. Thank you very much.
Thank you. Do you wish to speak to that?
Yeah, I'll speak to two things. The comment on how far the septic system has to be from the rear property line, I would defer to David Rogers, our chief building official, to confirm. I think he might be looking that up right now just to confirm, but I was informed by Sean that those setbacks did not apply to septic systems. Yeah, hi Andy, that's Sean here. I'm not sure what the setback is from the rear property line, so our chief building official will look into that right now. But I also wanted to comment that the reason I'm recommending approval of the application is to keep that septic system, well, for one reason is to keep the septic system to the rear of the property as opposed to needing to construct it in front of the property, because technically speaking, a septic system is only required to be 15 meters from the high water mark. And I was concerned that if we push the building envelope back to the 30 meters, that could result in the septic system being constructed in the front yard as opposed to the rear yard. So that was part of the
okay, well, I'm looking at that.
Hi, Andy. I'll finish first and then you can speak. Thank you.
Okay, sorry.
Yeah, so that was my rationale behind me supporting the application.
Okay.
I think that we have one other party on the line who wishes to speak to the application. Mr. Webb, do you wish to speak to your application?
Yeah, I'll just be brief. My family's been cottaging on Quagga for 42 years, and we were super excited when the lot next door came for sale, just to give my wife and I a chance to kind of continue that family tradition. I had Mr. O'Callahan, Mr. Grady come out to the lot and see my vision, and it made it clear to them that it is really important to me to blend in to the surroundings. I've never wanted a cottage that sticks out, and I made that clear to both of them. My vision is to have a bungalow with a walkout basement that fits perfectly into the grade there, and it's kind of hidden in amongst the trees. It's one of the reasons I've planted already 25 plus trees on our back lot, and would like to continue to do so. We got the lot 2 years ago, and one of the reasons I haven't proceeded with anything yet is it's just cleaning up the lot and trying to plan things to make things fit the way all my neighbors would sort of appreciate it in that space. I don't want to obviously move the cottage behind a garage and have a garage in front of me and the lake, and even for digging basements and stuff, it just sort of fits perfectly into that spot. And that's kind of my thought, and I'll leave it there for the time being.
Are there comments or maybe have you got clarification for us, Mr. Rogers, on requirements for the septic system?
And through you, Mayor, the setback is 3 meters for a septic system or the tank to a property line.
Thank you.
If I may, Madam Chair.
Yes, go ahead.
Madam Chair, we have a primary hydro line running through the rear of the lot that we have to stay away 3 meters, in some cases to 16 feet, which would restrict or limit where the septic system could go. Basically, a septic system, the tank goes 1.5 meters from the building. The bed then must be another 16 feet away from there. If you put a well on the property, the drilled well needs to be 50 feet away from the septic system. So I think if you're looking at the drawing that we've submitted, we are very limited. I think that where everything goes is going to really and truly be based on one of the conditions, and that is that it's surveyed by an Ontario licensed surveyor, someone that can stake out the building, side lots, setback from high water, and then we'll see where we can actually put that legal septic system and legal will that's governed under the province. Thank you.
Comments or questions from the committee?
Through you, Madam Chair, just wondering, it shows a future cabin to be constructed. I'm just wondering, I'm not sure if Mr. Webb or Mr. O'Grady would want to answer the question about how likely it is that building will be constructed in the future.
Yeah, I could answer that, member. They are accessory uses of 5% on that lot. If you're building a bunkie, it can be 485 square feet. It has to be 3 meters from any lot line and 30 meters back from the water. If there is room to build one, then Mr. Webb would have the opportunity as a right to go ahead and build it. Whether that'll happen, I think is probably, how much money do you have left, or when that might be done is unknown at this juncture in time. But if the area will support it, it would be approved under the zoning bylaw and a building permit would be issued.
Thank you. The reason for the question was that it seems that your septic system location is a little bit constrained by that future structure as well. Is that correct?
Yeah, and it may very well be, yes. I mean, the primary goal is to get the septic and the water in. If there's any room left, then hypothetically you could build a bunkie, but not at this juncture, not at this point in time.
I don't normally speak at this point to an application, but I think I'm going to. I personally have an issue with this application. I spent quite a bit of time on the lot, and I've got to say, Mr. Webb, it is a beautiful lot, and I could see why you'd be happy to be able to acquire it. However, seeing where you propose to place the cottage on the bank rather than on the level portion of the land It looks to me like there is sufficient room to build a cottage and have all the necessary pump, septic tank, septic bed on the property without considering the future bunkie. I would oppose this given the fact that it is an empty lot. I recognize that there is a garage there, but I don't believe it would be a great difficulty or hardship to move that garage. I get your point about not wanting the garage in front of the house. But I think that at this stage that there could be a little bit of different planning done to ensure that you met the setback requirements. The government has recently spoken to some new restrictions about new development within the 30-meter setback. And primarily for that reason, I cannot approve this application as it stands. But I'm only one member of the committee, and I would like to hear what other committee members think.
Madam Chair, it's Chris Wood speaking.
Go ahead.
I'd like to ask a question as to when that garage was built. I understood from what Mr. O'Grady said earlier that it was under an application and approved. Was that many years ago? Was that just recently?
The building appears to have been there for some time. Do you have a date on it?
There was a building permit issued. Unfortunately, the exact date I do not have.
It would be approximately 30, 35 years ago, probably.
Yeah,
that was the impression I got, that was a very old building. And to Madam Chair's point of how difficult would it be to, one, either move it or two, remove it and move your whole house and structure back and build your garage to the spot you would like it, as opposed to trying to accommodate the garage, which is an old structure. It seems to me kind of a backwards way of looking at this, and I would call it a building lot as opposed to a lot that's got a building on it, and you're trying to construct a house around that building, that garage. I could see that garage being torn down and rebuilt in 2 years from now, as opposed to a bunkie type of thing. So I also don't like the fact that there are many trees that are being removed to accommodate this structure. So, along the lines of what the chairman was saying, I would have difficulty approving this, and I would like to see some more thought gone into how this could be accommodated so it is set back further from the shoreline.
Thank you. If just hold on a moment, Mr.
Yep.
Webb. I would also like some information about. I know that this may have been in a time where there weren't the same kind of regulations, but normally we would never allow a garage to be built on a property prior to the primary residence being built without some kind of a bond. And I would like to know how it happened that structure was built prior to any residence, and why we would now accommodate a brand new development for the sake of a 30-year-old garage.
Yeah, so I'm not exactly sure what the zoning provisions of the day were. I do know that a building permit was issued for the structure. So in the township's eyes, it was a legally established structure and remains. It would be a legal non-conforming structure now. So.
Can I hear from other members of the committee, please?
Madam Chair, Gary Trapp here. I'm sitting outside here with a notebook computer and my battery is getting very low. I have a few minutes left. I just would like, before I make my comments, make sure that if I do get disconnected before the vote takes place, if we've got some way for me to chime in here, because I definitely want to vote on this property. My comment is, I I share some of the observations. My first thought when I looked at this property was that there are some alternatives probably available given the a level lot and so on, and it comes down to sort of desires versus trying to adhere to the bylaws. I'm a big fan of walkouts, so I can certainly understand the desire for putting a walkout, trying to uphold the bylaws where possible. And it certainly seems like there should be some alternatives here, given the lot and all the comments that have been made. So my leaning was definitely towards trying to make it work within the existing bylaws. Thank you.
Mr. Rogers.
I certainly see Mr. Webb's desire, and I understand they trying to put a walkout structure on this building. The only place to put it is where he's indicated on his site plan, and so I don't have a lot of concerns. I think Mr. O'Callaghan has given us a report that is showing us why it should be permitted, and I have no concerns with the.
It's short read.
I'm going to agree with John that to put it where it was with a walkout basement is the only option for that property. I do agree with you that the garage could be moved though, so that the cottage could be farther back. So
Just a comment on the garage, if that's okay. And Sean might be able to speak to this, or Mitch for that matter. It from the outside, that may be the opinion, but you check the poured concrete floor. Sean could sort of see inside. Of course, we were in COVID time, so he wasn't entering the building. But it is a very well constructed garage. On top of that, I know it's easy, and it is 100% not a tear down. And if you guys were able to go in there, yes, it could use some shingles. You would 100% agree with me on that. It's a cedar sided, and while it's easy for the committee to say, or for some members to say, tearing it down or moving it, that is my pocketbook, and it's not. So I'm already realizing that costs are a lot more than I thought they were going to do. I know that's not your issue, but I do think it is something to consider for sure. I'll leave it at that again for now.
Thanks, Mr. Webb. Other comments or questions? Could I have a mover and a seconder then to put the motion on the floor? Julia Short Read and
I'll second it.
Mr. Rogers, thank you.
Moved by Julia Short-Reed, seconded by John Rogers. Be it resolved, the Committee of Adjustment hereby approves minor variance application HMV 021/20 to seek relief from Table 2 of the zoning bylaw to permit a reduction in the required setback from the high water mark from 30 meters to 22.86 meters for the purpose of constructing a 1,900 square foot dwelling, a variance of 7.14 meters. Subject to the following conditions. One, confirmation be provided from an Ontario land surveyor that the proposed structure is not located closer than 22.86 meters from the high water mark prior to any clearing or site alteration or the issuance of a building permit. Two, that any on-site sewage system permits and reviews required by the township have been obtained and approved prior to the issuance of a building permit. And three, that appropriate construction mitigation measures be implemented, which shall include the erection and maintenance of silt fencing between the proposed building and the shoreline. Liz Danielson, yay or nay?
Nay.
John Rogers, yay or nay?
Yay.
Julia Short-Read, yay or nay?
yay.
Gary Trapp, yay or nay?
Nay.
And Chris Woods, yay or nay?
Nay.
That motion is defeated. I'll read another motion, or I'll need a mover and seconder for the motion for denial.
Could I have a mover and a seconder for the motion for denial? And Mr. Trapp,
I will second.
Mr. Woods, thank you.
Moved by Gary Trapp, seconded by Chris Woods. Be it resolved, the Committee of Adjustment hereby denies minor variance application AHMB 021/20. Liz Danielson, yea or nay?
Yay.
John Rogers, yea or nay?
Nay.
Julia Shortreed, yea or nay?
Nay.
Gary Trapp, yea or nay?
My apologies. I was just checking with the technician here on battery and so on. Would you mind just?
The motion on the floor is now to deny the application. So we're looking for a yay or nay.
That motion?
I'm sorry?
Yay to deny it, yes.
Okay,
Yay to deny. application.
thank you.
Thank you.
Chris Woods, yea or nay?
Yay, but I'd like to make a comment if I could. If the applicant wishes to come back with a restructured design and fitting within the footprint and the setbacks, I'm sure that the committee could accommodate.
That would be welcome. I'm sorry?
So with the denial of the application, it would be a new application required.
Right.
Okay, I understand that. It's frustrating knowing that Andy just had a 42-foot variance go through by the same committee 2 years ago, which, you know, we did not oppose. In fact, the owner, Andy's dad, you know, invited my dad over and they talked through the building. We've always had a good relationship there. I can't see how, you know, you have an argument about, you know, keeping the lake in good condition. But 2 years ago, you just moved up to 42, or, you know, pushing the cottage behind the garage, and you potentially end up now with a septic system in front of the cottage. It's even closer to the lake than it would have been with a 75-foot variance. So I hope you guys sort of understand my difficulty with it on those. It just doesn't seem to connect.
Mr. Webb, I understand your frustration and your disappointment. I would say several things. First, this is not this exact same, these are not the same committee members. There have been a number of changes made by the province about what their expectations are in planning that we have to follow, and some of them have come into place within the last several years. And I still believe that there's the ability to develop the lot in a way that allows you to put your septic tank or your septic system behind the house, but we'll leave that for discussion for another day. So that is the end of our business for today. If I could have a motion, a mover and a seconder to adjourn the meeting. Julie Shortreed, second by John Rogers.
Moved by Julia Shortreed, seconded by John Rogers. Be it resolved that the Committee of Adjustment hereby adjourns its regular meeting at 2:41 p.m. Liz Danielson, yea or nay?
Yay.
John Rogers, yea or nay?
Yay.
Julia Shortreed, yea or nay?
Yay.
Gary Trapp, yea or nay?
Gary, are you still? He's not with us. I think we can proceed with.
Okay. And Chris Woods, yea or nay?
Yay.
Okay.
Thank you to the committee of the members and to everyone who has been in attendance.
Do we have a meeting in October, Sean?
Oh, sorry about that. We should have set a date for the next meeting.
So So I have received a couple applications. However, I am not available on the 30th of October, being the last Friday of the month. So I will send out to the committee some proposed dates, and we can set it that way.
Are you available on the 23rd?
Yes, I believe so.
Would the committee members be available on the 23rd of October?
Yes, I believe so.
I think so, but I'd have to check my calendar.
Okay, I'll ask Sean to send out a clarification note and
Yes,
just make
please.
sure that we're all available, particularly as Mr. Trapp is no longer with us.
Thank you.
Thanks again, everyone.
Thank you.
Thank you. Bye.